Xbox on. Siri, what's the weather going to be like today?
Here's the forecast for today.
In today's day, electronics have seemed to become man's best friend. And to protect these electronics from unreasonable search and seizure in the Fourth Amendment is important to people like you and me because of an exponential increase in smarter technology.
This topic's important today because of a surge in better technology that can make the Fourth Amendment a controversy. Law enforcement and the government have been infringing on the people's Fourth Amendment rights, and now with the recent terrorist and criminal attacks, electronics can hinder the prosecution of criminals. This is also making people lose their unreasonable search and seizure rights at the same time. A good example of electronics coming into conflict with the Fourth Amendment clause, unreasonable search and seizure, is in the Supreme Court case Kylo v. U.S. in 2001. In Kylo v. U.S. in 2001, the court addressed the constitutionality of using technology to survey the inside of a defendant's home without actually entering the home. Here, the court held that physical invasion was not required to constitute a Fourth Amendment search if the surveillance reaped information that would have not been obtainable without entering the home.
Plaintiff Timothy Carpenter was convicted of a series of robberies based on evidence of his travels provided by his cell phone company. The Supreme Court heard the oral argument Wednesday. This is an hour and 20 minutes.
We'll hear argument this morning in Case 16-402, Carpenter v. United States. Before we commence, though, I'd like to advise counsel that I'll provide an additional 10 minutes of them to their argument time. I don't think you'll have trouble filling it. Mr. Wessler.
Thank you. Mr. Chief Justice, and may it please the Court. At issue in this case is the government's warrantless collection of 127 days of petitioner's cell site location information, revealing his locations, movements, and associations over a long period. As in Jones, the collection of this information is a search, as it disturbs people's long-standing practical expectation that their longer-term movements in public and private spaces will remain private.
So what is the rule that you want us to adopt in this case, assuming that we keep Miller and Smith versus Maryland on the books?
The rule we seek is that longer-term periods or aggregations of cell site location information is a search and requires a warrant. We are not asking the Court to overturn those older cases. We think that the lesson to be drawn from Riley and Jones and Kylo is that any extension of pre-digital precedents to these kinds of digital data must rest on their own bottom.
How would you distinguish Miller?
Miller involved more limited records. Certainly they could reveal some sensitive information, but more limited records, and as this Court held, they were voluntarily conveyed and that they were created by the passing of negotiable instruments into the stream of commerce to transfer funds. What we have here is both more sensitive and less voluntary.
Why is it more sensitive? Why is cell site location information more sensitive than bank records, which particularly today, when a lot of people don't use cash much, if at all, a bank record will disclose purchases. It will not only disclose everything that the person buys. It will not only disclose locations, but it will disclose things that can be very sensitive.
I absolutely agree, Justice Alito, that the information in bank records can be quite sensitive. But what it cannot do is chart a minute-by-minute account of a person's locations and movements and associations